They convicted Marcus Whitfield of espionage in 1987. Life sentence, sealed exhibits, case closed. Then, in 2019, a records clerk in Alexandria, Virginia, found a docket number stamped on one of his original filing folders. A number that traced back to a court that, according to every public index, never existed. So why was a man convicted using evidence generated by a proceeding the federal government insists was never held? The official story was simple. Whitfield, a mid-level contractor at a defense firm outside Washington, was caught passing documents to a foreign handler. The FBI built the case on surveillance logs, a wiretap warrant, and testimony from 2 informants. The trial lasted 6 days. The jury deliberated for 4 hours. Whitfield always claimed the evidence against him had been manufactured somewhere he was never allowed to see, a hearing he wasn't present for, a judge whose name never appeared on any public roster. Nobody believed him. Sealed evidence in national security cases wasn't unusual. The judge presiding over his actual trial had top-secret clearance. Case closed, chain of custody intact, at least on paper. The docket number changed that. It read M1187, followed by a case designation format the clerk had never seen in 31 years of filing federal paperwork. She ran it through the archive system. Nothing. She ran it through Pacer, the public court records portal. Nothing. She finally found a match in an internal cross-reference log used by the Foreign Intelligence Surveillance Court, the body that approves surveillance warrants in secret without the target ever being notified. The M prefix, she learned, belonged to what insiders call a shadow docket, a case file that generates real legal authority, real warrants, real evidence, but leaves no public trace, no published opinion, no case number a defense attorney could ever request. Here's the contradiction the trial record can't survive. Whitfield's defense team, back in 1987, requested the full chain of custody for the wiretap warrant that started the entire investigation. The prosecution handed over a warrant application, signed and dated, citing probable cause developed through established investigative channels. That phrase was standard boilerplate, until you match it against the M1187 folder. The warrant wasn't developed through established channels. It was developed through a hearing that occurred 9 days earlier, in a docket that officially does not exist, before a judge whose commission was never disclosed to Whitfield's attorneys because they had no legal right to know he existed. The wiretap that convicted Whitfield was fruit of a tree the defense was never told was planted. This was never allowed to surface because the shadow docket isn't just secret, it's structurally unreachable. FISA proceedings are exempt from standard subpoena power. The judges rotate through anonymously. Court reporters sign non-disclosure agreements that outlast their careers. Even Whitfield's own trial judge, sources close to the case say, may not have known the surveillance authorizing his prosecution came from this parallel system. The room where M1187 was heard has no address in any public directory. The case number itself was designed to be unsearchable by anyone without insider access to the cross-reference log, which is exactly how the clerk stumbled onto it. It wasn't meant to be found. It was a filing error. But the docket number wasn't the strangest part. Buried in the same folder was a second document, a routing slip, dated 3 weeks before Whitfield's arrest, transferring surveillance product from M1187 to a second, entirely separate shadow docket, M1203. 2 secret cases run in sequence feeding the same investigation. Legal analysts who have since reviewed redacted portions of the file say this kind of docket hopping, moving evidence between sealed proceedings, makes it nearly impossible to ever trace where an investigation actually began, or whether the original probable cause held up at all. Coincidence stops looking possible once you realize the transfer date lines up exactly with when Whitfield's handler first appears in FBI records, as though the surveillance came first, and the justification was assembled around it afterward. If the warrant that started it all was built on unreviewable authority, Whitfield's entire conviction rests on a foundation no court, no appellate judge, no journalist has ever been permitted to examine. Whoever created the shadow docket system benefited from exactly this, a permanent shield against review. Whitfield died in federal custody in 2011, still filing appeals citing a case number nobody could confirm existed. His lawyer still has the folder. The Justice Department has never acknowledged M1187 or M1203 by name. No public record shows how many cases besides Whitfield's ran through them, or whether they're still active today. So the question isn't whether the docket was real. The clerk found it. The question is how many other convictions are sitting on the same kind of foundation, and how anyone would ever find out.